On a scale from 1 to 10, 1 being like completely sober, and 10 being the most intoxicated you've ever been, what would you rate yourself?
0.
But you just said you were
0.
intoxicated.
Well, I haven't slept in 24 hours.
Okay.
Because I just flew down here from Alaska yesterday.
Exact date of this incident is not confirmed in the footage metadata.
How are you doing today, ma'am?
I'm good.
Good. I'm Officer Becker. This is my partner, Officer Tate. And we just want to see what was going on.
So can we move her out of the way?
Let's move out of the way.
Call you? Nope.
Okay, here, let's, do you want to take your bag and we'll just move over to the side?
Is your mom here? We're just gonna go right up here. Right here.
Yeah, just right here.
My mom called you.
So go ahead, what's going on?
I think my mom called you.
Okay.
Right?
Have you had anything to drink? Any alcohol?
Yes.
Okay. How many drinks of alcohol did you have?
2
2 what?
wines.
2 wines? Okay.
Yeah.
Do you know what size? What size were they? You could give me a rough estimate.
Like a glass.
Okay. 2 glasses.
The glass
Okay.
is like 6 ounces.
Okay.
Yeah.
How did you get here to the airport?
I arrived from Seattle.
Okay. Do you have your boarding pass?
Yes.
And do you have an identification?
Yes.
May I see it, please?
What is happening right now?
We're just checking up on you,
I mean, thank you.
making sure that you're okay, and making sure that everything's going okay.
Okay. Great. I love that.
So what we're doing is we're doing a mission for intoxication. Okay, so we got called on you for possibly being intoxicated. That's why we're here talking to you. Okay? Is that yes? You are intoxicated?
Yes.
Okay.
Okay.
I mean, yeah.
Okay.
Okay.
She already agreed that she's intoxicated. Take her and we'll just a minute. Okay.
Hold on a minute. Okay. On a scale from 1 to 10, 1 being like completely sober, and 10 being the most intoxicated you've ever been, what would you rate yourself?
0.
But you just said you were
0.
intoxicated.
Well, I haven't slept in 24 hours.
Okay.
Because I just flew down here from Alaska yesterday.
Okay.
So
go ahead and put your ID down for us, please.
Oh, of course.
All right.
We're gonna move your bag.
Okay. Turn around.
All right, we're gonna take this bag. We're gonna take this bag off of you. Okay.
Okay.
I'm gonna have you put your hands behind your back.
Just grab her hands.
Okay.
So you're under arrest for public intoxication at this moment. Okay. Hold on. We'll fix it. Take it off.
Okay.
Take it. Hold on. Just relax.
All right.
Close them back.
Yep.
Close them back. Okay. Let's start over.
Okay.
Yeah.
We can go here.
Okay. I know. Check
The tightness, yeah.
Okay.
Is that too loose?
No, it's fine.
Okay.
Let him know on channel 2.
Edward 4, we have 1 in custody on public intox. We're going to take you to jail for public intox. Okay? Over here. Okay, I'm going.
We're going to go to the front
Yeah,
of the car.
I just need to unlock it. Okay, this way. Okay, and we're going to have you stand right here in front of the vehicle for us. Okay, watch your step. Thank you. Okay, we'll have you stand right here for me, please. Okay, go ahead and spread your feet. Okay, we're going to walk over just a little bit. There we go.
Spread your feet apart. you have anything on you that can hurt misdemeanor your book? No. Do you have anything in your bra? No. No? Okay. Do you have an underwire bra on? Fast.
Yep. All right. Best way to get in here is just to take your step up with your left foot.
Step up.
There you go.
Keep going.
Go ahead. Keep going.
Push. Push. Get your right foot up on that step. Put your right foot up on that step.
Also, I'm handicapped.
Okay.
You can do it.
You can do it.
You're almost there.
Push.
There you go. There you go.
All right.
Mrs. Backer and Tate responded to a complaint filed by the subject's own mother. To Florida v. JL 2000, a third-party tip alone cannot establish probable cause. Independent officer observation is constitutionally required before any arrest. Subject appeared upright, oriented, and coherent from first contact. She immediately asked whether her mother had called, demonstrating full situational awareness. This level of orientation contradicts the legal threshold for public intoxication. Then initiated an alcohol inquiry without first conducting any sobriety assessment. Subject admitted to 2 glasses of wine, approximately 6 ounces each. Ohio, 1964. Probable cause requires articulable facts, not mere admissions. Consuming alcohol is not itself a crime. Incapacitation is the legal standard. Produced her boarding pass and government ID on request without hesitation. Fine motor coordination and document retrieval are inconsistent with legal incapacitation. To rate her intoxication on a scale of 1 to 10, she answered 0. Explained she had not slept in 24 hours after flying from Alaska via Seattle. Sleep deprivation produces physiological effects that may mimic alcohol impairment. Courts have recognized this distinction in contesting public intoxication charges. No standard field sobriety test was administered at any point in this encounter. No preliminary breath test was requested. No objective evidence of impairment was documented. Within seconds of her explanation, officers proceeded directly to physical arrest. The Fourth Amendment requires that warrantless arrests rest on independently observed facts. Here, the arrest basis was 1 family complaint, 1 verbal admission of drinking. Neither element, individually or combined, satisfies the constitutional probable cause standard. Subject was informed of her arrest only after handcuffing had already begun. See under Berkemer v. McCarty, 1984. Miranda rights attach when custody is established. The moment officers instructed her to put her hands behind her back, she was in custody. Any prior statements made without advisement carry potential Fifth Amendment suppression risk. Incident to arrest was conducted, constitutionally authorized under Chimmel v. California. However, the lawfulness of a search incident depends on the lawfulness of the underlying arrest. Probable cause was deficient. The search may also be subject to Fourth Amendment challenge. During vehicle loading, the subject struggled physically but did not resist officers. Graham v. Connor, 1989. Force must be calibrated to threat level and active resistance. No threat was present. No resistance occurred. Physical assistance remained within legal bounds. Backer, radio dispatch. 1 in custody for public intoxication. No test cited. Of any test result from the radio call is consistent with none having been performed. Public intoxication statutes across U.S. jurisdictions share a common threshold. The individual must be unable to care for their own safety or the safety of others. Who answers questions, retrieves documents, and walks unassisted does not meet this bar. Case outcome is unknown at time of analysis. No court records were located. On the legal record, any public intoxication charge here faces serious evidentiary challenge. Civil claim under 42 U.S.C. Section 1983 for unlawful arrest would carry potential merit. Section 1983 allows individuals to sue state actors for constitutional rights violations. Grades. Backer receives a C+. The welfare check approach was lawful. Demeanor and physical control were professionally managed. However, no objective sobriety assessment was conducted before the arrest decision was made. Probable cause rested entirely on a family complaint and 1 verbal admission, legally insufficient. Fourth Amendment demands more. This arrest exposes the department to civil liability. Tate receives a B-. Conduct and demeanor were professional throughout. Physical assistance during loading was appropriate. Co-responding officer, he shares accountability for the failure to recommend sobriety testing. No affirmative step to request objective evidence before arrest is documented in the footage. Subject receives an A-. She remained calm, cooperative, and articulate from first contact through vehicle loading. She complied with all lawful instructions while clearly communicating her physical condition. Her voluntary admission of alcohol consumption, however, was legally damaging. Amendment: right to remain silent applies during custodial encounters. Declining to answer questions about alcohol consumption was her constitutional right. 2 lessons learned. For law enforcement, a third-party complaint is a starting point, not probable cause. Conduct objective sobriety testing before any public intoxication arrest. Document everything. Advise Miranda rights the point custody begins, not after handcuffing is complete. For the public, you have the right to remain silent. Exercise it early. Everything said can be used. Cooperating physically does not require answering questions about your own conduct. You believe an arrest is unlawful, comply in the moment. Challenge it in court. Physical resistance escalates risk. Legal remedies under Section 1983 are the proper channel. Let us know if there is an interaction or legal topic you would like discussed in the comments. Thank you for watching.